Hi, my name is Tripp Stroud, founder and attorney at Valley View Law, based here in beautiful Spring Green, Wisconsin. We're a criminal defense firm. We represent the hardworking people of rural Wisconsin that have been brought into court and accused of a crime. And you might be watching this video because that describes you or someone that you care about. Well, you've come to the right place, because in this video, we're going to tell you a little bit about what to expect when going to court for a criminal case. But before we begin, let me just say this. Be calm. You're going to be okay. You're going to make it through this, and you're going to bounce back through it. Not only are you going to make it through this, not only are you going to survive, but you're going to bounce back from this stronger and better than ever. All right? So without further ado, here we go. Very quick intro to what the criminal process is like here in Wisconsin. All right, so what are the different steps along the way in a criminal trial? Well, Wisconsin has a set of laws called that make up our criminal procedure. And so no matter which county you're in Wisconsin, the criminal process follows pretty much the same pattern everywhere you go. Each judge might, or each court might have different terms, but generally these are the steps that you take. 1, the criminal complaint, then the initial appearance, and then there's discovery, and in some cases a preliminary exam, and then there's the pretrial phase of the criminal procedure, and then a trial. And after a trial, if there's a conviction on any of the charges, there's the sentencing phase. So I'm going to go through each one of those very briefly to just describe what to expect at each stop along the way. All right, so the next phase, and usually the first appearance with an attorney in court, is called the initial appearance. And the initial appearance is meant to take care of a bunch of different things. So 1, this is your opportunity to enter a plea. Usually the initial appearance will start out with the judge reading the complaint that's been filed against you. And if it's a lengthy complaint, or if the facts are, we just don't want them to be said out loud in court, we might just waive a formal reading of the complaint. So but the judge is supposed to offer that opportunity to read out the charges and make sure that you as a criminal defendant understand them. Then the judge is going to ask, how do you plead? And this part of the initial appearance is sometimes called an arraignment. But basically you have 4 options. You can plead guilty, no contest, not guilty, or you can stand mute, in which case the judge will interpret that as you're pleading not guilty. In a different post, I'll explain what all those different pleas mean, but for purposes of this video, we just want to say very early on, this is the stage where you enter a plea. Almost all the time, I recommend my clients plead not guilty. Other things that we can take care of at the initial appearance. Since this is the first time more likely than not, this is the first time you're being represented by an attorney in court, this could be an opportunity to try and modify your bail. If you had to post a significant amount of money to get bailed out of jail, or if the bail conditions are onerous or burdensome or interfering with your life in an unreasonable way, this could be an opportunity to get in front of the judge and say, hey, we should probably consider changing the bond conditions for my client. Here's why. Another opportunity that the initial appearance presents is the chance to swap out judges. So you have the right to request a new judge in a criminal trial. And you can request a new judge for any reason. You don't have to say it's because I don't like you or because whatever. You don't have to say anything. You just say, we're going to substitute. You just file with the court that you want a substitute judge. You don't get to pick who the substitute is. It's going to come from someone either within the county or a nearby area, and then that person will preside over the rest of the proceedings in your case, and that will be your judge for the duration. It's important to consider whether to substitute judges, because some judges are known for being understanding, for being pro prosecutor, for being pro law enforcement, for being former defense attorneys. So always a strategic consideration to keep in mind whether to swap judges. So how all initial appearances wrap up this way is the court wants to schedule a checkpoint with the prosecutor and defense counsel to make sure that progress is being made on the case, either towards settling it or developing the case for trial. And so some scheduling back and forth happens, and the court opens its calendar, and we agree on a time to meet next, and that's it. Most initial appearances last about 2 or 3 minutes. It's very quick. And the next time you're in court will likely be a scheduling conference or some kind of return date to be back in front of the judge to let them know what's up with the case. But that's all for initial appearances. Next up is the discovery phase of the criminal proceeding. So what is discovery? It's basically a set of procedures that allow me as your defense attorney to see what's inside the DA's file. What do they have on you? And in parallel with that, to do my own investigation. And sometimes that might mean a combination of hiring a private investigator to interview witnesses and try to chase down facts and evidence related to your case. It could mean open records requests, going to the sheriff's department or to other law enforcement agencies and getting recordings of 911 calls, dispatch calls, police reports, all sorts of stuff that's supposed to be open to anybody, anybody in the public. And a lot of times there's very valuable information inside those materials. It also gives us an opportunity to subpoena third parties. A subpoena is a court power that's given to attorneys in some cases to demand people that aren't part of the proceeding, that aren't named in the lawsuit, to cough up documents related to your case. So if this is an identity theft case or an embezzlement case, we might want to subpoena records from the relevant bank accounts, credit card companies, and accounting records, all that sort of thing to help get to the bottom of the facts related to your case. If you're charged with a felony, one step in this discovery phase is called the preliminary exam. The preliminary exam is basically a checkpoint on prosecutors to make sure that they have enough evidence to back up the charges. So prosecutors aren't overcharging cases with the felony, and they basically need to prove that they have enough to go forward to the trial phase. The preliminary exam is an opportunity for your defense counsel to interview the police that investigated the charges against you and ask some questions to see what kind of evidence they have that made them believe that you committed the crime that you're charged with. There is a very low bar for prosecutors to win a preliminary exam, but it can be an important strategic checkpoint in your case because, one, prosecutors don't like to do preliminary exams because it makes work for them. And so that's a bargaining chip that we can use to get something from the prosecutor, whether it's a favorable term in a settlement or what have you. But it's also an opportunity to see what the police officers are like, the ones that, if it comes down to it at trial, are going to testify for the prosecutor against you. And so we get a preview of what they believe happened and what kind of testimony that they're going to give. And it gives us an opportunity to get them on the record with testimony that might be helpful for us. So that's the discovery phase. A lot of times that happens on the that's me and my team doing an investigation for you, and it's very important to work with me, for you to work with your attorney closely and answer any questions and help them follow up on leads so that they can start to develop the facts that support your defense and that can help get you off the hook. The next phase of the trial is what I call the pre-trial phase. So sometimes, and I'll just side note, sometimes these phases, the discovery phase and the pretrial phase, they can kind of overlap a little bit in terms of the tasks and activities that I'm going to be working on for you during those stages. in a nutshell, the pretrial phase, we're pretty much getting ready to wrap up the case at this point. And there's going to be two ways that the case wraps up. One is going to be we reach a favorable settlement with the prosecutor where you enter a plea to the case, or we get the case dismissed, as the case may be, in return for you doing something for the DA, or the DA doing something for us. So that's a settlement. The other way it can wrap up is by going to a trial. But during the pretrial phase, what I'm going to be working on is presenting all the evidence that I've been able to build up over the course of investigating your case and your defense. I'm going to be able to present to the prosecutor, this is who you are as a client. And this is the strength of our case, maybe even some of the weaknesses of our case. And we're going to give the DA, my job is to give the DA compelling reasons to give you what you want out of a settlement. So that might mean saving you from having to go to jail or a prison sentence. That might mean a shorter term of probation. That might mean a diversion agreement, like a deferred prosecution agreement, that's going to eventually lead to the charges getting dismissed. But that's an important part of the process, this back and forth with the district attorney to help them understand who you are and what the strengths of our case are, so that if it does go to trial, they feel like they don't have a very good shot of winning, and that they want to work with you and to come to a favorable settlement with you. Other things that happen during the pretrial phase is we get to go to court sometimes to argue about evidence that should be allowed at your trial. This can be very important. It's your right as an American to be protected from illegal searches and seizures by law enforcement and by the government. And if you're pulled over illegally by law enforcement, or if you're stopped on the street, or if law enforcement searches your home in a way that's not permitted by the Constitution, then we get to argue to the judge that that evidence, whatever evidence was gained from that illegal stop or seizure, should be thrown out. And if we win that case, if we win that argument, then oftentimes that means we win the case, because without, let's say in an OWI case, without being able to introduce evidence of the stop and what happened after it, there's no proof of an OWI. So motions to suppress are very important parts of the pretrial phase. Another important part of the pretrial phase is getting together with the court and setting the ground rules for the trial. So some ground rules might be what types of questions we can ask witnesses, what types of things we can say during trial or can't say during trial, what types of evidence are going to be out of bounds. So for example, we can make arguments which are called motions in limine, fancy legal term, for excluding certain types of evidence, like out of court statements made by a witness who isn't going to be able to testify. We could say, Your Honor, that's hearsay, it's inadmissible, and you should enter an order that prohibits either party from introducing that particular type of hearsay evidence, that particular statement that someone made about you outside of court. That's just an example. So that's the pretrial phase. Very important phase, because this could be where we come to a very favorable. If we've been able to develop solid evidence backing up your defense, and we've been able to negotiate successfully with the DA, we could settle your case, or we get it ready for trial, which is the next phase. All right, now we're talking about trials. We've gone through every stage of the criminal process up till now, and for one reason or another, we have not been able to reach a favorable settlement with the prosecutor. That's okay. That happens sometimes. And if you have an attorney that will fight for you and will stand up for you to protect your freedom and to get you what you want, then sometimes you're faced with having to go to a trial. Trials are exciting. They can be nerve-wracking, but they're exciting because this is your opportunity to tell your story. The components of a trial are the prosecutor gets to tell their side of the story, their facts, why they think you are the one that committed this particular kind of crime, They'll call all the witnesses that they think support that case. This is your opportunity to be heard as well. You get to call your own witnesses. And this might even be the first time that you get to confront the prosecution's witnesses, people that you haven't been able to talk to or get a statement from. This is your opportunity to have me go out in front of the court and question those people, to elicit your side of the story, to make you look better, and to convince the 12 people sitting in the jury box that you shouldn't be found guilty of this crime. Another component of the trial is that the prosecutor carries a very heavy burden. They have a tough job. They have to prove each element of the offense that you're accused of beyond a reasonable doubt. That's a very high burden to meet. Our job is to create those doubts, to tell your side of the story that creates those doubts in the jury's mind about whether you're the person that committed that crime, or whether what the prosecution is saying is true. Lots of strategic thinking and decision making goes into a trial, so it's very important to work closely with your attorney and to tell the attorney the truth, and to be there when they ask you to be there, and to provide the things that they're asking for when they're asking for them, so that when we arrive in the courthouse, when you arrive in the courthouse at the beginning of the trial, you're feeling prepared and your attorney's feeling prepared and you're ready to go with your case. All right, so we've gone to trial and the jury has come back with a verdict. That verdict could be, if all 12 jurors agree that you're guilty, then then we move to the next step of the criminal process, which is sentencing. We'll come back to court and we'll get to argue in front of the judge what your sentence should be. The prosecution will have their side of the story to say, and they'll have a recommendation in terms of what your sentence should be. Should you get the maximum punishment? Our Wisconsin statutes prescribe what the maximum punishment is for certain types of crimes. And in some cases, the statutes prescribe a minimum level of punishment for that crime. We also get an opportunity to argue, and there's a range of factors that we can argue to the judge in terms of where in between that minimum and maximum your punishment should land. But just like preparing for a trial, this is an opportunity to persuade the judge to be sympathetic to you, and to ask for the mercy, for leniency, and to have the judge be open to granting you second chances. So just like with the trial phase, it's very important to cooperate with your attorney and to meet with them and give them the information that they need to help put on a good sentencing argument in your favor. So that's it. That's a criminal process in a nutshell, a very, very, very small nutshell. We went through it very quickly, but my goal is to help give you some peace of mind. If you or someone that you care about is being charged with a crime and you want to know what's coming down the road for them as part of their upcoming court dates, that you have a little bit more information and you can sleep a little easier at night knowing what to expect.